the last panel. So thank you for sticking around. I am going to introduce our panel topic and then introduce our panelists, and then we will get into it. So this is Futureproofing the Brand, Modern IP Protection Strategies. So today, brands just don't live in packaging or in ads. They exist across different platforms, social media, AI-generated content, and global digital marketplaces, which makes protecting them even more complicated than ever. So as the ways that we create, distribute, and consume content evolve, so do the risks to a brand's trademark, copyright, and overall integrity. So this panel brings together perspectives from both in-house and private practice to explore how companies are adapting their IP strategies to stay ahead of infringement, dilution, and emerging technologies. And we'll talk about what future-proofing really means in practice. So whether that's leveraging new enforcement tools, navigating cross-border challenges, or rethinking traditional approaches to protection. And the goal here is really to move beyond what sounds good on paper and get into what is really working in terms of practice today and how we get ready for tomorrow. So introducing our first panelist, Angela Coxe, who's a partner at ESCA Legal and a seasoned patent attorney with extensive experience in patent portfolio management, including patent preparation, prosecution, and strategic management of patents. She looks at innovation holistically to determine the best strategies to protect her clients' innovations to the fullest extent by filing patents and monetizing patents using patent sales and licensing programs. She successfully obtained patents for her clients in computer, hardware and software, printmaking technologies, mechanical arts, mechanical devices, and consumer products. Angela graduated from Lafayette College with a double major in math and computer science, received her JD from Weiner University Commonwealth Law School, and has an LLM in intellectual property law from the George Washington University School of Law. Next, I'd like to introduce Cassidy Merriam, who is a business-minded attorney with over a decade of comprehensive legal experience, specializing in intellectual property, advertising, marketing law, entertainment law, and commercial transactions. She currently serves as senior corporate counsel at EchoStar Corporation, where she plays a key role in driving marketing strategy for Dish Network and Sling TV, and handles all trademark, copyright, and licensing work across the organization for Blockbuster, Dish, Sling, Boost Mobile, Gen Mobile, Hughes, and EchoStar brands. Known for her collaborative spirit and growth mindset, Cassie's experience spans both law firm and in-house roles. Her work has been featured in Attorney at Law magazine, Bloomberg News Law, and the New York Intellectual Property Law Association Bulletin. She earned her JD from Brooklyn Law School and has a Bachelor of Arts in English and American Studies from Occidental College. Next, we have Vinny Minhas, who is the head of MarqVision Americas, which is a leading online brand protection software that helps global brands identify and remove counterfeits. To date, MarqVision has helped facilitate takedowns across over 1,500 platforms and thousands of rogue websites in 118 countries. Vinny uses data from MarqVision to help brands create broader offline strategies, including proactive measures like raids, partnerships with law enforcement, and collaborations with government organizations such as CBP. By blending customized strategies with scalable technology, he aims to rebuild resilient programs that effectively balance automation and human insight. He also serves as co-chair of the Anti-Counterfeiting Coalition, which is the world's largest nonprofit dedicated to solely protecting intellectual property. And then we have Sofya Nadgorny, who is the vice president, senior trademark, and domain name counsel at Warner Music Group, where she oversees the company's global trademark and domain portfolio and advises on all aspects of trademark clearance, use, filing, enforcement, and brand strategy. She works closely with business and creative teams to protect and advance Warner Music Group's iconic roster of artists, labels, and brands across platforms and territories. Prior to joining Warner Music Group, she spent a decade at the Nature's Bounty Company, serving as IP counsel and data privacy officer. She earned her Juris Doctor cum laude with a concentration in IP from Touro University and holds a Bachelor of Arts in Philosophy with a minor in Rhetoric from the University of Maryland. I am Cece Cole. I am IP counsel at Versant Media, which owns brands including MS Now, CNBC, E! News, USA, and others. I work with the different businesses to advise on copyright claims, trademark clearances, and all other IP issues. I also spearhead our programmatic enforcement efforts and work closely with our cyber team to handle our anti-piracy initiative. So, and before that, I was in private practice, and I graduated from law school at Cardozo Law, and I went to undergrad in New Orleans at Tulane University. So with all of that, let's jump in. So Angela, my first question for you is what should, we have the early stages of building a brand, right? We're starting to set up our brand, think about our IP portfolio. So what should really be like the first step for any startup or small business or brand that wants to proactively protect its IP?
That's a great question, because I feel like a lot of brands, when they start, they have ideas. They just want to like run with their idea and build the business. But what you really need to think about is your IP strategy early. You need to think about what your goals are for the business and think about protecting them before you really launch your business, ideally. And in order to do that, you should do an IP strategy audit, which then you can figure out, what's my corporate structure? Is my IP assigned to the company? Are my employees required to assign their IP to the company, or is it assigned through their employment agreement? And then what products, services are we going to be featuring, and what are these points of novelty or the aspects that are the most valuable that we are going to need to protect? And then look at, if there are any registrations, what they are, and seeing how they fit into the whole package of what your company is and how you plan to grow the company. And then figure out a way that you're actually going to continue to monitor and actually capture this intellectual property as your company grows and evolves and as the market changes over time, which then leads to, after you do the audit, to then go and actually make an IP strategy roadmap where you're going to lay out the next step. So you can prioritize what's the most important thing to you and budget and put in place everything you need to make sure you are going to be able to capture the intellectual property, follow your strategy. So then when you launch, or as you continue to grow, you are able to continue to move forward and make sure you are protected, so you don't have to worry, oh no, is something going to happen? You're going to be, yes, I know, this is my plan. Plans can change, but you're going to keep checking in on your plans. And then using those techniques, you're going to continue to evolve and grow and change your roadmap to follow that along.
And I think like that makes sense. And one thing I meant to mention was that all these views are our own and not like representative of our companies. So just have to give that little warning. But I think that makes sense, right? There's a lot you have to think about when you're first starting to set up your brand's IP portfolio and what you want it to look like. So Cassidy, I'm wondering though, like if you are working with a limited budget, right? So you set it up, but you also have to enforce it. So if you're working with like a more limited budget, what are some examples of like nice to haves versus need to haves? And how do you think about, I have this brand, but I can't do it all. Like, what do you suggest?
Yeah, I would say the top things that any smaller or scaling business should do is, and systems they should have in place, are a good way to clear trademarks and other IP. I think that's probably a worthwhile spend. You can do it through the USPTO's website, but it's a clunky system to use. And I think if the goal is to really get good results quickly so you can, not waste time spinning wheels to clear a mark, that's, having an industry standard search tool is probably one of the top things to have. I would say having trademark watches set up is probably also a worthy endeavor, especially for your really important marks, your house marks. It's a lot easier and a lot cheaper to stop an infringing use if, you can do it through a cancellation proceeding, as opposed to, once they've been using a long time and you're down the road and you're in a litigation. So that's also probably a worthy endeavor and would save you money on the back end. And then I think internally, it's really important to have good systems set up, whether that's for document management software, contract management software, which are different things, and then having policies forcing all your employees to do it. And it's easy when you're a little shop to just be like, oh, we do it this way, and so saves their documents in Google Drive, and the other person does it here. And that can become out of control so fast. Like, all you need to do is hire a few more people, and then it's, oh, we've always done it that way. It works fine. But, once the toothpaste is out of the tube, you can't get it back. And so I think having policies in place If it's not going to be a perfect system for everyone, too bad. This is the one you use. This is how you save documents. This is where what needs to be saved and how it needs to be named, and whatever will make it easier down the road to access anything that you might need to access. I would say, it's a very important thing to do early on.
I would add that you also should have, I think you're implying this like NDA, confidentiality, and any kind of like licensing agreements, really make sure that you have those in the beginning too.
Yeah. Oh, go ahead, Vinny.
No, I was thinking solid point. I mean, it's making sure that the trademark watch service is critical, right? Especially with a smaller brand. They don't have an unlimited budget to really file everywhere. And there's a lot of countries that are first to file versus first to use. And quite often you're going to see infringers from those countries tracking online sales to see how they're doing. So it's important part to be very proactive in that part.
Yeah, on that point. And it's not just like your typical watch. We have word, logo, domain. I know some companies do color. Some companies do a watch on their competitors to be on top of what their competitors are doing. And to your point, it's much cheaper. We actually go even further back. So like, I'll do a watch on new applications. I won't even wait for publication. So I could get ahead of even not having to, if I can avoid having to file an opposition, I'll either reach out or I'll have our local counsel reach out and just be like, listen, just expressly exclude our industry or expressly exclude these goods or expressly exclude these services, or limit it to just like whatever, if you're in the automotive business, but you're in the same class as me and your spec was way too broad, just limit it to your use, and that takes care of the issue. You don't have to have a file. You don't need to file an opposition. You don't have to do a cancellation. You don't have to do any of those things, right? So yes, very useful, like introductory tool to preempt a lot of future issues.
Yeah, and I feel like you hear that a lot of, doing all of these like things initially, whether it's setting up watch notices or getting these different tools and functions, that it's kind of like spending now to make it easier later, hopefully. And I think, from the legal side, we've seen that through a lot of times, but it's also having to get the business side and the budget in line with that, and like advocating as to why.
I'll speak to that.
Yeah, those are needed. Yeah. So I think that like blends nicely, Sofya, into our other question of like, when you do though have like more of a robust IP portfolio and you have a bigger international presence, like how do you decide what stays internal? Like how do you manage that workflow? And then how do you decide what gets like kicked to outside counsel and managing that budget too? Because
so my answer is going to be broader than probably what your question is, but it does answer it, but like fully answers that. So I was lucky enough in actually both of my roles where I came in and it was a blank slate. So I had the luxury of designing the workflow and the enforcement and all the stuff, like the system to work for me, right? But before you, like, how do you even know what you need? You talk to the business people, you see what they care about, you see what your budget is, you see what portfolios, matter more than other portfolios, and you get the risk appetite and you get like, what do they care about, right? And then it's you get the tools. There's so many tools out there, right? And it's a matter of figuring out what is best suited for you, right? Like, don't get a bazooka if a butter knife will do, but don't get a butter knife if you need a bazooka, right? Like, there are instances where, for like me, like all I really need is the docketing system that I use is a SaaS-based one. I could just drag documents in. A lot of it's just me and a paralegal, right? So like, I just need something that takes care of a lot of like the nitty-gritty stuff. But I don't need more than being able to drag my documents in, save. It has like an API that pulls in all the information. So if I know it's Canada trademark and this is the application number, like it just pulls everything in, right? And for the USPTO, it's even better. It pulls everything from the USPTO in. But then like I have colleagues that work at ours as a service, like our widget is a service. They work with a portfolio of actual products, like whether it be jewelry or watches or clothing. They have product images. They have product numbers. They have sales data. They have a lot more information about their portfolio with the use, the where, the how much it was sold. And now there are systems where like the bazooka I was mentioning, like I'm sure there's more out there, but like there's one that I saw that's called Obviously, where it has the docketing system. Then it has like you put in all of your like product images and all of your product information. And then you have like all of like your invoices and your sales data and your et cetera. And then like you could put in all of the emails that you had with counsel over the past like 5 years, when you like filed an opposition and see what worked and what didn't work. And then it uses AI to do all sorts of things with all that information. Super cool. Like if you're at a, I don't know, like a Tiffany or a David Yurman or whatever, like I don't need that kind of, like, I don't have product images for a song or like a record label, right? But those types of products do. So getting a proper system that's going to work for you. And then it's like the next step, enforcement, right? Like word, logo, domain makes sense for us. Maybe if you're like Tiffany, it makes sense to have a color watch. And even within that, like the workflow is our big, like the reason we're so scrappy, I leverage everything I possibly can. So like for takedowns that we can do ourselves, AI. Like my paralegal does, here's the information, he gets the first draft, he tweaks the first draft, sends it to me, and then off he goes and sends it to like the registrar, the host, whatever, right? Let's say he's not really having a lot of success. Sometimes like other teams within the company that you wouldn't think, like our InfoSec team has a much bigger budget than we do. Mm-hmm. And they had some sort of vendor that was for like impersonation fraud, but then had a tacked on service that has something to do with like, oh, we'll watch your marks for you. I was like, not watch, we'll like, if there's you can have like 5 marks and then they'll go and action it. So I was like, oh, good, you do the first run.
You take that budget.
I don't need to pay. You're already paying for it. Like send it to this guy. Like if it works, great. If not, then we'll do our version, right? And then sometimes like social media teams for the record labels or for the merch team, right? Like they already have those relationships. So instead of me sending out like a takedown to like the ether of whatever, they already have a person. They have an email. So you could leverage that relationship and get much further. And then it's like, that doesn't work. There's trade organizations. So like in our case, there's the IFPI, which is like a big trade organization internationally for all of the music labels and et cetera. I'm sure there's like, I think for movies, it's the MPA. Every industry has its own. And they typically have like a resource where like you can send them this stuff and they could try to get it down for you if, let's say, the infringer isn't just infringing like our music, they're infringing like Sony and Universal as well. So like let them do it to the extent that you can. Work that into your workflow, but like logically, right? You move out. And then last resort or, depending on how bad it is, go to outside counsel. And then the other thing too is education. I'm really big on empowering like our business teams, and they're really receptive to it too. You'd be surprised. They don't want to email you about like, oh, can I get this domain and have to wait for you. If they knew that they could just go on whois.com and see if it's taken, like they would do it. That's not that difficult, right? Or when they send us like, oh, we want to use this name for a new record label or something, and I have to say like, it's not available. Instead of just saying it's not available, I then go like, by the way, here's a prompt.
Yeah.
That's super helpful. Just have AI like brainstorm, right? And like I didn't even know how to construct this prompt. So I went into like Gemini's, our approved enterprise AI, and I'm like, help me build a prompt for a record label marketing person who is thinking of doing blah, 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 blah. And so it came out with this whole like genre, vibe, examples of like what you want, like as a feel, blah, 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 blah. So like once they come to you, they're not coming to you with something you're like, this is a knockout, this is a knockout, this is a no, whatever. Like they're actually coming to you with something useful. So that as far as like workflow design, right? Like you educate them. So a lot of stuff doesn't even have to come to your desk. Like a lot of this stuff is just preempted before the work. It doesn't even enter my workflow because I've already educated, I've empowered them. They're doing the first like 3 steps. I don't want to do the first 3 steps.
And it's interesting, like, I feel we've all probably experienced in different ways of, like, how AI has come to streamline a lot of those things or how you use it in order to streamline. And you have to think critically about where it's helpful and where it's not your first line of defense. So, kind of with that, and, like, as we've had more emerging technologies, like, Vinny, I'm wondering, like, what are some of the roadblocks that you've seen, like, newer brands or newer portfolios, what have they run into that was kind of unexpected, and how are you counseling your clients to think about their IP strategy, especially in like a digital age?
Yeah. So with the digital space, you have a much broader outreach than having a brick and mortar store. And there are problems that come along with it. Brands are using AI, but so are the bad actors as well. So they're actually going on Amazon and using tools like Jungle Scout to actually track sales and see which products are doing well. And guess what? They're manufacturing those products and then they're selling it as well. So part of some of the roadblocks that we encounter with some brands early on is they may not have an unlimited budget to file Madrid Protocol, file the registrations everywhere. So you really have to take like a sophisticated prescriptive approach onto where you want to have your filings. There are tools out there, just like ours, that can understand where your products are most relevant and most present to give you that visibility. And those are the areas I really want to start to file your trademarks and registrations into. Now, as I mentioned, you do want to have filings in China, right? It's first to file there. And quite often, we're seeing a lot of large amount of counterfeits coming from there. And why is that important, even if you're not selling to China? Because there are marketplaces that are global that ship to the US, like Alibaba and AliExpress and DHgate, plus other ones that are more legitimate. But guess what? If you both own trademarks, one in China and someone else owns in the US, you can kind of counteract some of the takedowns there. So now it's up to the platform and what to really do. So those are some of the roadblocks we typically see is brands don't know where to file. And a lot of it has to do with how relevant the brand is and where they're actually selling.
Yeah, and I feel with that, you have to have a really deep understanding of your own brand and what your goals are. And to what you were saying before, like it's up to the platform. And I think this was something that we touched on earlier is having relationships with those platforms. And like, I think Sofya, was you, they were saying like you could send a DMCA takedown into the void, but it's also a lot easier if I can email my partner at YouTube and, flag that I had put something in. So I think, especially for someone like me that has just recently moved in-house, it's very eye-opening that like at a firm, that would be probably my first and only line of defense would be sending a DMCA takedown and saying feeling like that's all I could do. Whereas in-house, it's very interesting to leverage more of those relationships that you have to make with the platforms to kind of move that along. So kind of like sticking on this topic of AI and these roadblocks, like Angela, I'm wondering, kind of as AI is evolving and, we're having like, it's very easy to replicate something else online, as you were talking about earlier, especially in dupe culture. So like, how are you shifting the way you counsel your clients on like patent protection and portfolio management in terms of like their long-term enforcement strategies?
I think that a lot of the strategies are the same, but it's really just focusing and really emphasizing the importance because everything is moving faster. AI just has helped us move faster, be more efficient, but also it just leads to if you are developing something, you need to do your filings early. Like Vinny said, for China, in the e-commerce space with AI, for patents, you have a year from when it's publicly disclosed. But ideally, you want to file a patent before you actually have your product out there. That's just one thing, especially as a patent attorney, that I just focus on so much. And it's something that people just don't know about always, right? So it's that education part, the early filings. Then, like Cassidy said, you need systems in place and checklists and ways to capture and evaluate the innovation, the ideas, the products, services you're offering, and really determining how to best protect them using systems, processes, checklists along the way. And then strategic filings. Again, you want to leverage what are your core products, services, what's core to your brand, what do you really need to protect, and then what territories you protect them in. It's just so important with this. And then specifically for patents, you really need to think about where is this going in the future and what are different variations or how is this field going to evolve over time? Because you need to predict the future in some ways or predict where future products are going to go. Your products, competitor products, you want that landscape to be as broad as possible. Are there other industries that could use your technology but use it in a slightly different way? I always tell my clients, I was like, think that your idea is here and it's like a small circular world. You want to capture the world around it. And like how far you can go around it we do patent searches too, in addition to, I know a lot of people are familiar with like the trademark searches and everything, but we do that with patents too. And it's just like, we want to see how broad we can kind of go. We don't want it to go too broad, but we want to see, can we get a space around that? Because those spaces really are the areas where we can capture things and then provide that protection, especially if it's something new, foundational, that we can then have that protection on. It's really important, and it's especially important with AI. And then we have to just think of the infringers and enforcement early on while we're doing the filings. Who do you think is going to infringe you? How can you provide some protection that protects your brand by doing your own filing that might allow others not to come into your space or not to come into your space as much, such as like the detection, what's in just the jurisdictions. And then also think outside of the box. Many of us are legal, but then there's the business aspect of it. And how can legal business work together and really find solutions that may be a little more creative so that we can really create the right protections, have the right agreements in place, so then when things happen, as things grow and shift, we are prepared for that the best that we can be.
I just want to, so like from a trademark perspective, the way we like future proof, so because we have these vintage, long-standing, like some of our marks went from like 19 or whatever, registered for gramophone. And one thing that I found to be very helpful to give a lot of like optionality, because, a new marketing person comes in and the first thing they do is rebrand, right? Like, and you like the last guy's like new logo, whatever, hasn't even registered everywhere yet. But like the nice thing about like Warner is like these are really old established brands, but they'll tweak it, right? So as far as like future proofing and to the extent that you can, right? Like there's the word portion, there's like some sort of design, there might be a color involved. So to be more specific on how it is that you go about future proofing and you're like filing strategic, like what does that mean, right? Strategic filing. So from a trademark perspective, strategic filing literally means like, does it make sense? Sometimes I'll do the logo, the word. Maybe I'll do a combo for an area where I don't want to spend that much money. I'll have like, so there's like usually like, there's 3 buckets. There's the word, there's just the design, and there's the combo mark, right? And in my material markets, I might do the word and the logo. But then in like a less material market, but like I want to make sure I have something, but I don't want to pay for the times 2, I'll do the combo instead, right? It gives you a little more leverage. And then for like territories, right? It's like, what is strategic territory? You could go about that in so many different ways. Like you'll ask your client, but like they don't even know what that means. Like, is it your top 10 territories of sales? Is it where you know that you have like potential that like it makes sense defensively even if you don't have sales? Is it your industry? Like for our industry, there are material markets for the music industry, right? So like whether I have used it or not, or whether I'm going to use that mark there or not, like I should still have it in those material markets. So it's really like, I call it like mixing and matching. Like you measure 5,000 times, you cut once. You also kind of like do all of that work on the front end where like, as much as maybe you might want to file the word and the logo in the UK, there's already so much there that you can already preempt like all these potential objections or oppositions. Like maybe it'll make more sense to do the combo with a color and maybe only in like these classes, not all your classes, or maybe all your classes, but in like the ones that are problematic, you specifically limit it to just your industry and don't make it as broad. There's just like so many different ways. When you say strategic, there really is like so many options where the goal really is that you preempt as much as you can on the front end so that like when you do file, like you are most guaranteed to have a smooth registration and you at least have like the most that you can possibly have in that territory to be able to enforce as much as you can.
And I feel like that's kind of been the theme here is that how you have to approach, protection and enforcement is it's evolving, right? It's getting more complicated, or you have to be more strategic, or you have to make like these different decisions based on the information you have. So Cassidy, I'm wondering, like, have you seen like IP, like policing and enforcement strategies change, like especially as infringers are, I feel like now more than ever, counterclaiming on takedowns? And like, how do you deal with that, or like, how do you respond to that, or how do you adjust?
Yeah, I think it's changed in a number of different ways. It makes me think about how, and I think somebody even mentioned it in one of the earlier panels about, tailoring your cease and desist letters so that there's not a PR disaster from it. And when I was in law school and younger practicing attorney, there were all these, and there probably still are, like kind of quirky, funny cease and desist letters that go viral as like, when Bud Light came and they like...
Jack Daniels, remember that one?
The Jack Daniels one. There was like a town crier that came to this release of some infringing beer and he like, dressed up. And I think that's fine. But like, what brands can you think of that are successful that were ruined over a cease and desist letter? I mean, maybe something blows up for a little while, and maybe you want to, if it's some, fan thing on Etsy, like, yeah, maybe you want to be gentle about the way it's written, but like, I don't think we need to go over the top to protect our brands and to worry about the PR related to doing what you legally need to do to stay a brand. Like, be a bully sometimes. Like, I don't know. I just don't care. Like, you can think I'm an asshole. You can post my cease and desist on social media. Like, Disney is probably the most aggressive IP enforcement company that any of us could ever think of. Is anyone like, I'm not going to watch the new Disney movie or ESPN or Hulu or whatever because Disney, wrote me a nastygram over, some Pinterest post that I had. Like, no, we just accept that they're trademark bullies and we love their brand. And so you get over it. So I think like an overemphasis on being too PC is like a waste of time and really makes no difference.
Which is hard, which is an interesting balance because we live in a world where that is for some departments, it's their biggest consideration. And for other departments, it's not their first priority. So I think it's also like, as being in-house, it's having to align the legal and the business to be on the same strategy in terms of when or why we enforce things, when or why we take down things. Like, what is our ethos around enforcement, policing, response? And it's very different from company to company and also from
department to department. I was going to say,
Yeah.
like, there's like, we have a bunch of different labels, all with their own ethos, all like, some are dormant, some are, it depends.
Yeah.
That's why I say, like, it's so important to go and talk, like, before you even do anything, find out who cares about what. I've had labels that are like, I don't care to register it. I just want to know if I, like, as long as no one can sue me, right? Like,
Yeah.
And then there's other ones that are like, why can't I register it? Like, I want to register. Like, so, and it's not across, like, maybe if you're a smaller brand or you have like one, a brand for the entire company, yes. But if you have multiple ones, like, not every brand, even within a portfolio, is the same.
Yeah. So I'm kind of, I'm wondering, Vinny, so we talked a lot about, policing and watching these brands and, sending a cease and desist letter, but sometimes you need to do more than that. Sometimes you have to file a litigation. So how does MarqVision help its clients, create a record if a brand does end up needing to escalate a takedown to litigation? And what tools are you guys providing to brand owners?
It's a good question. It was one of the panels earlier. There's been a big shift, I think, over the last 10 years. Everyone cared what was happening offline 10 years ago. Then it shifted to what's happening online. But now it's shifting back a little bit. How do you connect your online data to offline actions? And that's a key part about what platforms like us can do, is when we're actually looking and finding listings that are potentially infringing, we're categorizing those listings. We're capturing data on those sellers as well. And we take it a step further to see if they're repeat offenders. But as we're capturing those listings, we're actually capturing screenshots of those listings. We're keeping the evidence in perpetuity. And we're using that to see if they come back in different aliases and different names, because certain platforms will actually give you information about that seller. Not so much in Europe because of GDPR, but there are other countries that will give you business registration numbers. Who's a legal representative? From there, you can actually cluster those sellers together to see if this is one person or one large group that's acting in coordination, and that you can pass over to do some offline litigation for. Whether that's Schedule A or you're doing deeper investigations, we've leveraged this data to track down factories and worked with local law enforcement in China to get down to the root of the issue. Obviously, there's many sister factories, so taking out one won't solve it, but having something proactive that hits the PR and showing that you're doing something about it goes a long way, because you want to apply constant pressure over a period of time to mitigate the risk. If you're sporadically just putting pressure, the problem's never going to go away. I always compare brand protection to almost like a pest control service, right? It's not something you could do 1 month. It's not something you can do 4 months down the line. You have to do this in a proactive way and stay on top of it. Obviously, if your brand is popular, the problem will never go away, but how do you have a better mousetrap to keep it to a manageable level?
Yeah, and it's hard to...
Yeah, do you guys ever, like, it's like a sidebar question, but I just got curious. Mm-hmm. Like, if you notice that there's like one bad actor for like one client, do you ever link like, oh, this same bad actor is doing like same stuff, but like for a completely other client, and then like compile all of that and like, I don't know, take it to like customs or whatever. Like I was just curious. Like,
we've been asked that so many times, and the problem with that is it's proprietary information for the customer we're working with. Although we could try to anonymize it, once we anonymize that data, we're actually losing some information.
But what if they both agree, right? Because I always know that, like, I remember, like, at some other conference that I was at, and they had Border Patrol, like, they always say that if you, the more egregious, like, the worse it is, the more evidence you have. Basically, like, the bigger platter and dish that you literally just serve to them, the better. The more like resources they'll put towards it.
It would be great if all the luxury jewelry customers were our customers, right? So we could do that, but a lot of times you are losing separate vendors. So there becomes a disconnect there. So if, anyone wants to come, all the record labels want to come over, that's not a problem.
IFPI? Yeah, why not? Well, it's good, the trade organizations, that might make sense.
Yes, it does, yeah. Especially for, American footwear, there's different organizations, toys industry, so there's a lot of collaboration you can definitely do. Pharmaceutical industry is a little bit tighter. They typically will share a lot of the same information to have proactive measures and work with one another. But a lot of times the dialogue stops within the brands. I've seen, not that they don't want to help each other out, but they're so busy doing their own thing.
Yeah.
So, but fair point.
And to touch on that too, Vinny is, an outside product that a lot of brands, MarqVision brands rely on MarqVision. So, Angela, I'm also wondering, having outside counsel is also really beneficial to companies or brands, especially when you have a small team and you need to rely, on experienced outside counsel. So, kind of what is something that, you find yourself constantly reminding brands, or when you work with people, differentiating what can be done in-house versus what's best served by experienced outside counsel?
I think it depends on the brand, but a lot of times when we are dealing with these smaller companies and smaller brands, we really need to kind of hold their hand and go through that, the audit process, then go through the roadmap and really keep them on track, which includes then monthly, quarterly check-ins and guiding them through things, which really is the way that we can help them to get ahead of issues and really figure out the best way to move forward, and then to get the value out of their IP and also leverage it when they need to so it can protect their brand. That's really, I think. But then certain other things that we could give them too are tools, right? We can help them with different NDA templates, and we can help them with certain licensing or their website, and help them, give them tips for how to protect the IP. And it's something then that they can maintain themselves, and they don't need outside counsel for because those things. And maybe we can teach them, like you said, you teach, okay, here, go do searches here, right? This is how you can do some at least preliminary searching before you come to me. So you're not incurring as much of those fees. And then I'm just focusing on really once you have solidified the idea, because we don't, I also can't be the filter for, all of the clients. And as smaller clients, as smaller businesses, they need a lot of hand-holding, but also if you empower them, they also embrace that and want to take steps proactively themselves to figure things out, which is great.
Yeah. And there's definitely, a difference between, working as outside counsel with the brands and then working as in-house counsel. So, Cassidy, I'm wondering, having done both, what do you feel, what skills do you need when you're an in-house lawyer? How do you feel it's different when you're counseling your client versus as outside counsel versus counseling your client when you work for the client?
Yeah, the thing that's really nice about working in-house is not billing hours. But I mean that in the most serious way, because you can take the time to really get to know the company, the business, the ins and outs, your business team, and develop a relationship that then can really streamline a lot of the stuff down the road, where you've got this sort of everyday working relationship with, whatever the 10, 20, 50 business people that you work with on the regular. And so the work is a lot more streamlined, but taking the time upfront to really know your business, know it well, to sit down with your business team. And, when they're like, okay, well, we just need an agreement with this vendor who does blah, 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 and they rattle off all these technical terms, there's nothing wrong. And I think that law firm lawyers have a harder time saying this, but there's nothing wrong with saying, like, stop. I don't understand at all what you're talking about. You're the expert in that. Please explain this to me like I'm in kindergarten, and then we can go from there. And I think that can help you then, develop a relationship with your business team where, they don't wait until the last minute to say, oh, we have this deal done and we just need you to paper it now. It's like, no, there are not business terms and legal terms. Everything is negotiable and they all work together. And I think if you can get your business team thinking of you as a partner throughout the process, whether it's, with the marketing team and they're working on a few different new names for a product they're rolling out, or, one of the business teams where you've got an agreement with a new vendor that's coming in. So I think, the number one thing is really establishing good relationships with the business team, always trying to get to the yes. I mean, I think there's been one time where something was an absolute non-starter for me. And at the end of the day, it's still not my call. Like if a VP wants to sign off on it and says, I don't give a shit about the risk. We're moving forward with this. Fine. Like that's your choice. Like my job is to just make sure that you're aware of the risk. But if you can get to the yes, it's not always in the way that the business team wants to do it. But as much as you can do that, then they're more willing to be upfront with you when something's going wrong, when something comes up, when they need something, because, their perspective of you is not, that's legal, that's where deals go to die. Like, you can get them to trust you, and then you can, save everyone a lot of time and energy. They won't be sweeping things under the rugs. I will also just say that if you go in-house, forget everything you've ever known about writing an email. You need like 1 to 2 sentences, maybe a bullet point here and there, and any longer than that, and it just doesn't get read by anyone at any level. And now as in-house counsel, like when my outside counsel sends me an email, every time I look at it, I'm like, oh my, are we kidding?
And because they were billing by the hour for it, so it has to be long.
TLDR. I literally have to do emails.
Everything.
At the top, TLDR.
Yeah.
And then you go into your spiel, but TLDR.
So I think on that point too, like, Sofya, like what, there's a lot of law students in here. There's some attorneys that are newer to brand protection or want to get into brand protection. So what's like one piece of advice that you would...
I'm going to give 3.
Okay.
I'm going to give 3. To Cassidy's point, and I don't think it's just firm. I think this is advice for firm, not just in-house, but it makes you a much better firm lawyer and an in-house appreciated firm lawyer. Firms tend to just like, here's the legal risk. Here's the theoretical legal risk. Here are all the things that can go wrong, and then stop, right? And then it's like, business is like, what am I supposed to do with this, right? Like in-house and a good firm lawyer are like, okay, so these are the risks. And here are your options, right? Like there's like 10 options that they're not going to do. Then there's like 10 options that they're like they would do if they had the money. And then there's like here's your spectrum of solutions, right? Like here's the legal risk, but then you have the next step. Like never just stop at here's my legal analysis, here's the risk, period, end scene. You then have to do the next step of like, what am I supposed to do with this? Like, what are my options then? Like, if you do this, the risk is mitigated this much. If you do that, the risk is mitigated more. If you do this, like you could really get rid of the risk. Like you get the idea. So that's 1. 2, also to your point, never say no. You really don't ever have to say no. Like the beauty of what we do is you could always make it a yes, right? They might not want to do all those things. Like they might not be willing to make this change and that change or tweak it here and add this word there and blah, blah, blah. But you never said no. You gave them the roadmap to how to make it a yes. And so in their head, the decision that like why it didn't happen is because they didn't want to do all those things, not because you said no. And then lastly, and I say this to all my interns, networking, right? But like it's such an amorphous, like what does that mean? I remember when I was younger, I was like, oh, it's so sleazy. Like, I want a job and I know that like you can give me the job, but we're all supposed to pretend and talk like we're not going to mention the fact that all I want from you is a job.
Internship program that like you applied for that I want you to send my resume in for.
Right. But we're not going to mention that. We're going to talk about everything but that, right? And so what I always what I tell them is like, 1 is network. There's 3 levels of networking, right? You should always reach out, LinkedIn, these types of conferences, blah, blah, blah. Meet the people who've been doing this for like 15 plus years, right? Like, and ask good questions. No one expects you to know more or even as much as they do. They judge you on your questions. So like, a lot of times I'll talk to students who you could immediately tell that their entire purpose was just to get in front of me, and that's where it ended, right? And I'm like, it's better that I didn't know your name. It's true. And so like, make sure, like, why are you speaking to me as opposed to anybody else, right? Like, and never, ever, ever, ever start off with, tell me about your journey. That's like the laziest question. As soon as you say that, I turn off. That's it. I'm like, I'm done. I don't even want to get to know you. Mainly because, like, I don't know, I was born on a cold winter night. Like, what? I'm supposed to know what part of my, I'm not going to mention my age, journey is supposed to be useful to you that you care about. Like, as opposed to if you were to be like, oh, I saw you went from like one industry to a completely, you were in the consumer products, and then you went to like the music industry. How did you pivot? Pointed question. I saw you went straight to in-house. How did you do that? Pointed question, right? Like, the quality of your questions are what you're going to be judged on, like not how much copyright law you know within the realm of AI, with like speaking to somebody who's been doing this for like 20 years, right? So speak to those people. Speak to and connect with the people that are 5 years out from you. They know things and have advice that I took the bar exam. I'm not going to tell you how long ago, right? Like I can't give you advice on how to get a first job. I'm on my second or third, whatever, right? Like, but those people very recently went through the bar, the internships. They have the connections. They understand you. So meet those. They should be part of your network. You should be reaching out to those people and meeting those people just as much as the ones that are like in a hiring position. And then lastly, your peers. I can't tell you how many times I have hired interns because this is a really good one. There was a girl. I had an intern. He had already moved on, and he reaches out to me and he's like, hey, I don't know if you're looking at interns right now, but there was this girl who reached out to me and asked me about like my experience. She was thinking of applying for the internship, and she really impressed me and thought I'd tell you. And I was like, oh, who is she? I look her up. I sent her a LinkedIn message like, insert his name, told me that he spoke with you. Like, if you're still interested, schedule some time. She had like the initiative to go and talk to one of my interns, ask him about it, impress him enough to then have him tell me about her so that I then reached out. You know what I'm saying? Like, I thought that was like so good. And this was, her working the peer network. Like, these are her peers. So don't just think about like the person who can hire you. Think about the person who's 5 years out and the person who's sitting next to you who also maybe might have interned at the place that you want to intern now. And now they can put in a good word for you.
And I think that's what we were saying before is like everything is very strategic. Everything is it's also a lot of things are very serendipitous. You truly never know, especially in this very small world of an industry. But I think, that said, there's a lot to learn, and there's still, the industry is still evolving, right? The way you respond, the way you react, the way you are proactive about your strategies and your initiatives is constantly changing. So, there's a lot to do and a lot to learn, but that is our time. So thank you so much to our lovely panelists. Thank you to ESCA, and please make sure to do your CLEs. I don't know if we have time for questions. We're standing in the way of happy hour. So that sounds more important, but please feel free to come up and ask us questions. And thank you so much for staying through the last panel.